Alec Murdoch gets sentenced in federal court. That's right. The low-country disbarred attorney who's already serving a life sentence without the possibility of parole for the killing of his wife Maggie and son Paul. Well, he had a date today with a federal judge in the district of Charleston in the great state of South Carolina. Now, the probation department, although nobody ever gets probation in federal court, prepares a pre-sentence investigation report. And that report recommended a sentence between 17 and a half years to 22 years in prison. But let me make something very clear. This was not a stipulation, and what the PSI or the attorneys recommend is simply that, a recommendation to the federal judge. A judge in the federal system will always tell the defendant, you understand, all those guidelines, calculations, it is simply a recommendation. One factor that the court needs to consider in coming up with the appropriate sentence, which fulfills the principles of sentencing, but is no greater than reasonably necessary to, punish and yet rehabilitate. Well, the federal judge said, guess what? 40 years ought to do it. So, on top of the 40 years, Murdoch not only has the life without parole, but he also has another 27 years in prison in state court for those financial crimes. And the federal sentence will run concurrent with his state prison term, and he will likely serve about all of those 40 years if his murder conviction are not overturned on appeal. So both the defense and the prosecution originally requested a 30-year sentence, but District Court Judge Richard Gergel, well, he had something else in mind. Judge Gergel said that he sentenced Mr. Murdoch to a harsher punishment than suggested because Murdoch stole from the most needy and the most vulnerable people, like a client who became quadriplegic after a crash, a state trooper who was injured on the job, and a trust fund meant for children whose parents were killed in a car accident. So, of Murdoch's 25 victims, 11 of them are still not publicly identified, which Gergel says are some of the most vulnerable. Judge Gergel explained that his decision sends a clear message to all lawyers, not only in the state of South Carolina, but across the country, to lawyers who steal from their clients, that it will not be tolerated. The judge noted they, the clients, placed all of their problems and all of their hopes on Mr. Murdoch, and it is from those people he abused and stole. It is a difficult set of actions to understand, the judge noted. Now, Mr. Murdoch spoke like he's entitled to do, and the judge and the victims that he stole from listened to him go on for another 13 minutes, stating that he's so filled with sorrow and guilt, and he did these two things to people that he cared about. He said specifically, quote, "I want to take responsibility. I want my son to see me take responsibility," end quote. Well, Judge Gergel said, it's my hope my taking... he also noted that by telling the judge that by taking responsibility, that people he's hurt can begin to heal. He also addressed his drug addiction and told the judge he didn't think that he would have committed these crimes had it not been for that opioid addiction. But the prosecutors, in response to that little statement, said no, because they believe there's still $6 million that remains unaccounted for as of today, and they have given the defendant, Mr. Murdoch, every opportunity to come clean and say where that money might be. The federal prosecutors say that Murdoch remained adamant that all the money went to drugs, but they said it just doesn't add up, which I've been saying all along. Anyway, the judge said that Murdoch was a skilled groomer and no impaired person could have pulled off a crime of this magnitude, the judge noted. So clearly not buying Murdoch's claim of drug abuse. Now, as you recall, last week, federal prosecutors said that Mr. Murdoch wasn't truthful when FBI agents asked him where more than $6 million he stole ended up and whether another attorney possibly helped him steal the money from his clients and his past law firm. The prosecutors wanted the judge to revoke their end of the plea deal with Mr. Murdoch on theft and other charges and order him to the maximum of over 100 years. Like I said, Murdoch, he's already serving that life sentence for the death of his wife and son, pled guilty to stealing the money from clients and his law firm in state court, and then was sentenced to 27 years, which the South Carolina prosecutor said is an insurance policy to keep him behind bars if the murder conviction is overturned. Now, the investigators believe that Murdoch is trying to protect an attorney who helped him steal, and that his assertion that more than $6 million in the stolen money went to his drug habit is simply not true. So let me tell you something that happens in the federal system, ladies and gentlemen. You know, you can do a stipulation like in state court. Judge, we want you to do this sentence, and everybody agrees, and the judge will usually give it the rubber stamp of approval. Most judges say, well, the attorneys know better what the case is worth, and therefore they can have a better idea of what the appropriate sentence would be. A lot of courts, like the federal courts, don't accept stipulated sentences other than in very rare circumstances. But the court in federal court always has the say, because the court has to consider obviously the nature of the crime, the victims. They have to consider the federal sentencing guidelines, but the court can always impose a maximum sentence of up to the maximum sentence. And there's no do-overs in federal court. Tell me the last time anybody's heard of a plea in federal court being withdrawn. That's right. Zip, zilch, never, nada, doesn't happen. And the judges warn everybody that regardless of what your attorneys may think the appropriate sentence may be, what the prosecutors are recommending, regardless of what the probation department prepares in that pre-sentence investigation report, it's ultimately the judge's decision. And here, Judge Gergel said, boom, 40 years. It resolves it nicely. The prosecutors get a little more time than they were asking for. The defense, although gets a little more time, not as bad as what it could have been, up to 100 years. And basically, everybody is happy. Now, if somebody asked one of Murdoch's attorneys whether they're going to appeal, and of course they said, oh, we'll consider it. There's nothing illegal from what I can tell based upon what I have seen and what I have read, based upon the sentencing as well as the plea agreement. I think there is no basis for it. And guess what? Federal case is done. Now, does that mean we're finally done with Alec Murdoch? Well, he's up on appeal on his state murder case. And obviously, if that were to get reversed, which I think there's a possibility. There's a possibility. I think the judge let in too much of the 404B evidence in that particular case, all the financial crimes and what have you. But there you go. We'll see. I think it'll be the SOB rule, and the courts will say, although it was unfair and probably prejudiced the trial in light of the overwhelming evidence, so be it. Now, obviously, the defense attorneys for Mr. Murdoch say this wasn't an overwhelming case of guilt as it related to Mr. Murdoch in the murder case, and that the financial crimes unduly prejudiced the trial against Mr. Murdoch. That will be the issue in the state court. But for now, the financial crimes in state court are done and in federal court. Next, Chad Dorman. Remember that guy? Remember the guy accused of murdering his 3 sons? And, well, his attorneys are asking the court to allow the jury to view the crime scene. Now, Mr. Dorman is accused of shooting and killing his 3 sons back in June of 2023. And a motion asks for the jury to view specific locations where the victims were believed to have been shot. The master bedroom, including the location of a gun safe, the children's bathroom, and a field next to the home, and the location of the fire department in relation to the home. The prosecution says allowing the jury to view those locations would give it a better understanding of the witness's testimony and photographic evidence that will be presented at trial. Now, as you may recall, Mr. Dorman is facing 20 counts, including multiple counts of aggravated murder, and his trial is scheduled to begin in July. Now, a judge ruled back on March 15th that police violated Mr. Dorman's Miranda rights during a custodial interview, and therefore his statement will not be permitted in the prosecution's case in chief. I'm not a big fan of scene views. We saw it in the Murdoch case. I can only think of ever requesting it once, and it was a civil case I was asked to try with somebody, and the judge denied it. normally, you have to tell a story, whether it be through the witnesses, through photographic evidence. I don't know what this judge will do, but I'm not sure it's worth going to see a house where I'm sure it's been thoroughly photographed unless there's something that the prosecution thinks will give some new perspective on the crime scene. Not a big fan of that, but hey, we'll see how it goes. I'm pretty much of the mindset that, hey, nobody listens to me anymore, so what does it really matter? Give you my opinion. Anyway, first, why is the prosecutor being so petty in the Brian Kohberger matter? Well, guess what? I think the news media has finally been watching CrimeTalk because if they watched our live last night, we talked about this very issue, and now it's all over the news today. Yes, the defense has filed an objection to the court basically stopping any of the surveying work that was being done to prepare empirical data so that the court can see that the trial needs to be moved out of Latah County. And I read to you last night from the memorandum in support of the objection to the state's motion for order prohibiting contact with prospective jurors absent leave of the court. And so the defense in this case has filed this memorandum, and it says the state has alleged that the defense has violated the court's order, and specifically that the state alleges the defense has violated the prohibition on discussing the identity, the nature of the evidence expected to be presented at trial, or the sentencing phase of the proceedings. The order also prohibits disclosure of any information a lawyer knows or reasonably know is likely to be inadmissible evidence in trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Now, the defense states that they are aware of all this. After all, the defense wrote the original order upon which it is based, and the state, however, misunderstands the prohibition in this respect. The defense is not disclosing information. The defense is asking prospective jurors in the county of Latah as to what information they are aware of that was previously disclosed vis-a-vis the press. Further, the revised order for non-dissemination allows for counsel to ask questions of the public to do its work. That's exactly what happened. Mr. Kohberger is preparing for his change of venue hearing and is mindful of what the court must consider and the available means of obtaining information for the evidentiary hearing. And as it relates to the relevant case law that guides the factors that a court must consider in the motion for change of venue, and the state's motion and court order intrudes on one of the ways the defense will seek to establish prejudice pursuant to Criminal Rule 21. And there they go on and they talk about basically that what the court is doing is impermissible. They should not have said, hey, stop everything that is taking place. And in fact, we have an expert who's going to testify at the hearing, a gentleman by the name of Brian Edelman, and he is going to explain his education. He has a PhD. He has an LLM, which is basically like a master's in tax. And he has a master's degree as well. He's going to provide testimony as it relates to his research experience, his jury research experience, and the numerous years in which he has been doing this type of work. And he is going to explain what the state is objecting to, which is information that's been drawn from the press. Now, like I said, this all started because some Karen gets a call and they think it's some sort of person trying to influence the jury because this person is hearing information that is not part of what they have heard. Doesn't mean it hasn't been in the press, but it means they haven't heard it. So this lady calls the prosecutors and said, oh my gosh, somebody's talking about the case. So the prosecutors immediately turned over to their investigators, and they find out where this is coming from. A legitimate company, a legitimate researcher who has done not only surveys as it relates to these types of issues in Idaho on numerous occasions, but across the country for decades. But there's more. Then the state finds two other people that say that they're completely shocked that somebody called them. And the defense is basically saying when the prosecution goes on a Friday afternoon after speaking with the defense attorneys and says, yeah, we're doing this because we're required to do it. We're not doing anything illegal. We're not doing anything unethical. The prosecutor on a Friday afternoon, curiously happens to be situated in the same building as the court, files a motion, basically ex parte, even though it was filed and they got notice of it. The court grants the order without a hearing. Needless to say, defense is saying, not cool, judge, you can't do that. This is affecting our client's due process rights. He's required that under the Fifth Amendment of the United States Constitution and the applicable section of the Idaho State Constitution. And guess what? You can't go doing that. And judge, you need to rescind that order. So we're going to find out tomorrow at 1:30 if that order is going to be rescinded. It should be. I think the judge jumped the gun, but he probably figured, I don't know what the heck's going on. We need to have a hearing. Prosecution's always right, so let's do that. The prosecutor, he is being petty. He knows this is required. He just doesn't want to take this case out of Latah County and move it to a larger jurisdiction like Ada County, like they did with Lori Vallow and Chad Daybell. Why? Because it's expensive. Now, the judge in this particular case, Judge, that's his last name, said he really doesn't want to move this case because it's inconvenient to him. But the reality of it doesn't really matter to him. It's to make sure that due process rights are followed and the defendant gets a fair trial with a fair and impartial jury. The state is entitled to that as well. Now, the prosecutor, when I say he's being petty, he knew this was legitimate. This is petty. And the motion to stop this survey should never have been done. This is done all the time in these types of cases, and the prosecutor knows that. And what a good prosecutor should do, and always say, Judge, I don't care when you want to try this case, where you want to try this case, but you tell me where and when. I will have my witnesses, I will have my evidence, and we will prove this case beyond a reasonable doubt unanimously to a jury of 12 people. But the prosecutor wants to keep it in Latah County. And at the hearing, based upon the affidavit of the researcher, guess what? He's going to say people are, in fact, biased against Mr. Kohberger. The court cannot ignore that information. So I think tomorrow afternoon, once the evidence is presented, I think the prosecutor is going to have some egg on his face. And I believe that the court is going to acknowledge that maybe they jumped the gun just a little bit. Anyway, the defense says we were basically done, but we were trying to get information from surrounding counties to see if there was any type of issue in those other counties as well. So let's wait and see. But at this point, my opinion is the prosecutor is just being petty. Next on the docket, the things are heating up in the Delphi case. All right. And you may say, Scott, what is going on in Delphi that hasn't already taken place already? Well, first, the courts issued, and I saw a little blurb about this the other day, but a viewer sent this to me as well, and it's the actual emails. The court issued an order saying, hey, I've received all these emails from concerned citizens about not having cameras in the courtroom, so I am going to make an order that these be sent to all of the counsel involved, and here they are. Just to give you a couple of them, Judge Gull, I am writing to relay my concern with your order for no media coverage in the Richard Allen case. The community, and I am not only talking about Delphi, it is a nationwide community, deserves to be a part of the trial. What are your reasons? Will you please reconsider? Another person says, Judge Gull, I'm writing to express my concerns regarding the Delphi, Indiana trial and the critical need for transparency throughout the legal proceedings. As a concerned citizen and a former paid advocate for the company I reside in, I firmly believe that transparency is essential to ensuring justice is served and maintaining public trust in the judicial system. The tragic events surrounding the murder of Abby Williams and Libby German in Delphi have deeply affected the community and garnered nationwide, worldwide attention. However, the lack of transparency surrounding the trial proceedings has left many unanswered questions and fueled speculation. It is imperative that the court and law enforcement agencies involved in this case prioritize transparency to provide clarity to the public and foster trust in the judicial process. This includes providing timely updates on the progress of the trial, disclosing relevant evidence, and ensuring that the proceedings are conducted in an open and fair manner. Well, most of the emails that were sent to the court were quite polite. There was only one that maybe somebody should have maybe taken a moment before they hit the send button. But hey, what can you do, I guess? Anyway, they all urged the court to televise the proceedings for full transparency. Just kind of like what I say. That's right, transparency. It's a good thing for the government to be transparent. Well, and when I say things are heating up in the Delphi matter, the state responded to the defense third motion for a Franks hearing. The Franks hearing is basically saying that there were material misrepresentations or omissions from the affidavit for various search warrants, and therefore they are invalid. Now, the state in this particular case, it oftentimes actually calls the defense liars. Okay. And I understand these guys don't like each other. The prosecutors in the Delphi case and the defense attorneys, and the judge doesn't like the defense either. But I'm telling you, you go to most courtrooms, the judge is going to admonish you if you start calling the other side liars. You have to be a little more eloquent when you do that. So instead of saying they just outright lie, you need to say things as it relates to, oh, they speak with forked tongue. I'm concerned as to the statements that have been made. I'm very concerned. I think there may be some ethical considerations that need to be considered here. That's how you get around calling somebody a liar. And that's what the prosecution is doing in their particular response. It says the defense outright lied in their motion and misrepresented the true findings of Professor Turco. Lieutenant Holman reported the truth, and his statements that Turco's findings were inconclusive was correct. The defense's statements that Lieutenant Holman somehow was misleading in his report is entirely false. When they start calling each other liars, ladies and gentlemen, you know things are going to get ugly. We may have a fisticuff. Maybe that's why Judge Francis Seagull doesn't want this case televised, because it's going to literally be one of those situations where we showed up to watch a trial and a fight broke out. Getting interesting, ladies and gentlemen. And I do hope the judge reconsiders and allows cameras in the courtroom for full transparency. Hey, let's face it. If the evidence is there and it's overwhelming and the government meets their case beyond a reasonable doubt, or meets their burden, find them guilty. That's the way the system works. Let's have the truth. Let's see. And the truth is legal and competent evidence that comes in at trial, not what somebody speculates it will be. Legal and competent evidence admissible under the rules of evidence. That's what matters. Let us see it. Next on the docket, Chad Daybell. We almost have a jury, ladies and gentlemen. I don't know if you've been watching. I have been trying to watch the jury selection process for Chad Daybell. And for those who aren't familiar with it, jury selection began there in Ada County, which is in Boise, Idaho. And the trial is scheduled to last from 8 to 10 weeks. And Chad Daybell is charged with the first-degree murder, conspiracy to commit first-degree murder, and grand theft over the deaths of his first wife, Tammy, and Lori Vallow's children, Tylee Ryan and J.J. Vallow, who was only 7 at the time of his death. Now, the jury selection had finished up on its 5th day. They ended, about 11 o'clock, 12 o'clock Idaho time out there. And I think they ended up about 12 o'clock Pacific time today out there in Boise, Idaho. They have enough jurors so that they can do their general voir dire to those jurors and begin the peremptory challenges. Now, this is a death penalty case, and it's critical for the court to have enough jurors that can appropriately try the case and stay impartial. That's a little difficult, obviously, because this has been a high-profile case, and there's been a lot of media coverage over the last 4 years. Now, the court needs at least 50 jurors because when everybody exercises their peremptory challenges, which are challenges where the prosecution can get rid of anyone and the defense can get rid of any potential juror for any reason. And when you do that, to get to the 12 jurors plus the 6 alternates, you need at least 50. However, despite getting to the magic number of 52 yesterday, the court is trying to give itself a little bit of a buffer. Why? Well, a lot of those jurors who've been qualified maybe didn't engage in individual voir dire, and there was nothing that jumped out at anybody for the information that they put on their juror questionnaires. So when they bring everybody back in, you're going to have people that are going to say, well, I filled out the questionnaire. No one really has asked me anything, but I didn't really think I would get this far. So I've got some hardships. Did I tell you about the vacation that I planned? Yes, those types of things will come up. Or somebody will say, oh, yeah, I need to get out of jury. This is really not good. Did I tell you my wife just happened to play the Netflix series on the case of Chad Daybell and Lori Vallow? I think I've made up my mind. People will do this, ladies and gentlemen. And so the court wants to have enough because if some of those jurors that are in that 50, the presumptive 50 jurors there, drops out, you got to have a couple to fill those in. If you don't have enough jurors to fill in those people that may get dismissed, guess what? You got to start all over again. That would be problematic. So it's best to have a few extra bodies just in case. Now, like I said, the court needs to get to the 18 jurors, 12 plus 6 alternates, and the alternates will sit in for the entirety of the trial, but only find out that they are the alternates when the actual jury deliberations begin because they're told to collect their things. They're not going back to the jury room. So we'll see. And over the course of an 8 to 10 week trial, the chances of losing a couple of jurors for the unknown, the unexpected, is bound to take place. So tune in Monday morning, 9 a.m. We will have the jury selection process, and hopefully we can roll straight into opening arguments. Now, the interesting thing about voir dire is everybody kind of pitches their theory of the case. The prosecution's talking about, hey, we don't have to prove who killed everybody. We just have to show that there was a conspiracy to kill everybody. And as long as you think somebody killed these people, close enough for us. Now, yesterday, Chad Daybell was kind of pitching his theory as well. He brought up a country song that he liked where shiny things aren't always gold, kind of referring to, that's right, Lori Vallow, that somehow this shiny little object, Lori Vallow, that he thought was, the greatest thing ever. I mean, Chad Daybell thought that, and that kind of rocked his world. Well, it turned out to be nothing but trouble, not exactly what he thought he was getting into. Obviously, that's the defense I've been saying is going to take place for the next 4 years. Chad Daybell is going to say, you know what? Here I am, middle-aged guy. This beautiful girl, woman, rocks my world. She wants to be with me. Next thing you know, everybody starts dying around me. I have no idea, but I'm just kind of going along with the moment. He's going to have some explaining to do for sure, but that's the theory of the defense that I see developing. Obviously, we'll have to wait and see what we find out, at least in opening statements, which is just a preview, not a guarantee, but you don't want to tell jurors something that you're not going to be able to promise them that comes into evidence. So we'll have to wait and see.